Hello friends, in the series on the income tax cases, today we will discuss a very important case which is based on the deduction of TDS when the assessee appoints some contractor to do his work. The question before the Allahabad High Court in the present case was that if the contract involves some commissioning, testing, which involves some technical part, and that technical part is to be performed not on behalf of the assessee but on behalf of the contractor, then in that case whether the assessee has to deduct the TDS on the contract allotted to the contractor at the rate of 2% under section 194C or at the rate of 10% under section 194J, that is for payment of technical services. This issue has been very well taken up by the Honorable Allahabad High Court in the case of Commissioner of Income Tax TDS and another versus Lalitpur Power Generation Company Limited. The facts of the case are like this. In the present case, the assessee is involved in the business of generation of power. The assessee has given a very big contract for establishing some boiler, turbine, generator and setup of some another plant. When this contract was allotted to the contractor, then in that contract it was mentioned that the contractor has to complete the contract and he is also responsible to demonstrate to the assessee that the whole plant is working properly, and he was responsible for the pre-commissioning, post-commissioning and for testing of that boiler. The assessee deducted the TDS under section 194C, but the income tax department held the assessee as assessee in default and passed the orders under section 201 on the allegation that the assessee has to deduct the TDS under section 194J because it was an indivisible contract according to the revenue, and it was the allegation of the department that the assessee has to deduct the TDS at the rate of 10% under section 194J and not under section 194C. When this matter was before the tribunal said that in a contract, the primary or dominant object of the contract would be seen, and it has to be seen that what is the primary object of the contract. The tribunal said that the technical staff is appointed by the contractor and not by the assessee in the present case, and the tribunal was of the considered view that the composite contract should not be dissected by the assessing authority to attract the higher rate of TDS provisions. At the same time, the tribunal was also of the opinion that in the present case the revenue should not have overlooked the dominant object of the whole contract, because in the present case from the reading of the contract it was very clear that the assessee has given the full contract to the contractor for the boiler turbine installation and for the plant installation, and it was the duty of the contractor to appoint the technical staff on behalf of the assessee, and the assessee has not directly appointed them, meaning thereby that the assessee has not made directly payment to the technical staff. The assessee has appointed the contractor and then the contractor has made payment to the technical staff. So the allegation of the department on the basis that since the contract is indivisible and hence the higher rate should be adopted, the tribunal was of the opinion that the revenue is not in a power to dissect the contract to attract the higher provisions. It was the opinion of the tribunal that the whole nature of the contract is to be seen and it should not be bifurcated into contract and technical part. The revenue moved the appeal to the Allahabad High Court, and the Allahabad High Court also upheld the order of the tribunal. Friends, this case is very important because whenever the revenue finds the TDS provisions, if the assessee has not deducted the TDS, they give one or the other logic that the TDS is to be deducted. When the assessee deducts the TDS, then they try to drag that the assessee has to deduct the TDS at the higher rates, but for that it is to be seen the true nature of the transaction, and only then the TDS provision should be applied. At the end of this video, once again I am repeating the name of the case. The name of the case is Commissioner of Income Tax TDS and another versus Lalitpur Power Generation Company Limited, and this case is reported in 483 ITR at page number 449, and the date of the judgment is 16th November 2023. Thank you, friends.